Okay, we could bring out Mr. Bradley. Okay, anything that we need to address on behalf of the state before we bring the jury into the courtroom? Anything on behalf of the defense?
No.
The podium needs to be facing the jury for closing statements. Okay, we can bring the jury into the courtroom.
Yes, ma'am. All rise for the jury.
Please be seated. Good morning, ladies and gentlemen of the jury. Has anyone read or been exposed to reading newspaper headlines and/or articles relating to this trial or its participants? No. Has anyone seen or heard television, radio, or internet comments about this trial? No. Have you read any news headlines and/or articles related to this trial or its participants? No. Has anyone conducted or been exposed to any research regarding any matters concerning this case? No. And have you discussed this case among yourselves or with anyone else or allowed anyone to discuss it in your presence? No. Okay, other witnesses on behalf of the defense.
Your Honor, at this time the defense will rest.
Okay, thank you. Okay, ladies and gentlemen of the jury, both the state and the defense have now rested their case. The attorneys now will present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time. Okay, closing statement on behalf of the state.
Please, court, counsel, ladies and gentlemen of the jury. Why the death penalty? More appropriately, Why is the death penalty the appropriate sentence in this case under these facts? This is not a vote or a referendum on whether the death penalty is an appropriate sentence or an appropriate punishment for the crime of first-degree murder. The Florida legislature has already declared with the enactment of the death penalty statute that it is an appropriate punishment. You think that that decision should be changed somehow, you should take that up with your legislatures, with your state senators or congressmen. It is not a decision here for this particular courtroom and in this particular court case. The question before you is the death penalty the appropriate penalty for this man under these specific facts? Before you answer that question, we really should discuss the process, like Mr. Brown went through with you during jury selection, of how do you get to the point of answering that question in this case. Remember that the starting point is that not every first-degree murder case qualifies for the death penalty. Just because a verdict of guilty has been rendered of first-degree murder, even if it is a premeditated murder, it does not in and of itself qualify the case for a possible death sentence. The legislature requires more. It requires that the state must prove something more than just first-degree murder, and that something is an aggravating circumstance. The legislature set out in detail what would qualify as an aggravating circumstance, which, if proven beyond a reasonable doubt to you, would qualify the case as a possible death penalty case. Now, while the legislature set out a number of possible different aggravating circumstances in the statute, it also provided that it only takes one to qualify the case as a possible death penalty case. As Mr. Brown discussed with you during voir dire, this is the point in the trial that you will begin your process of determining if the case qualifies for the death penalty. The first step is to determine whether the state has proved at least one aggravating circumstance beyond a reasonable doubt. If the state has done so, you must then determine whether that aggravating circumstance or a combination of aggravating circumstances that you may believe exist aggravating circumstances for you to consider. The first one is that the victim of the capital felony was a law enforcement officer engaged in the performance of her official duties. There's not really much doubt about that. You've answered those questions already in the verdicts that you returned in the guilt phase in this case. Clearly, you answered on the murder verdict form that Barbara Pill was a law enforcement officer. In the resisting with violence charge in the other count, you also found that she was in the performance of her lawful duties at the time of the resisting that charge. But even without your prior verdict, remember back to the testimony in this case. Clearly, Jim Troop had worked with Deputy Barbara Pill for a number of years at the Sheriff's Office in the South Section. They worked together, wore uniforms, riding marked patrol cars, responding to calls. And clearly on March 6th of 2012, at the time she was shot dead, she was in the performance of her official duties, investigating the incident that had occurred at the Econo Lodge, investigating the robbery that had happened there, trying to apprehend the suspects, in this case, Mr. Bradley and Ms. Kirchner. Clearly, there has been proof beyond any reasonable doubt that that aggravating circumstance exists in this case. The second aggravating circumstance is that the capital felony was committed by a person previously convicted of a felony and on felony probation. You don't need to go any further than to look at exhibits 184, 185, and 186, which are the certified copies of the judgments and sentences of Mr. Bradley in 4 separate felony counts, where he first was sent to prison and then to be followed by a period of probation. You'll remember the testimony of Charles Colon, the probation officer that Mr. Bradley had back in late 2011 and early 2012, that although Mr. Bradley had discontinued reporting, violated his probation, and had outstanding warrants for him, he was still on probation even though he was in violation status. Clearly, that aggravating circumstance has been proven beyond any reasonable doubt in this case. A third aggravating circumstance is that the defendant was previously convicted of a felony involving the use or threat of violence to the person. You remember the testimony of Officer Colon again, that one of the cases that Mr. Bradley was on probation for was a robbery case. You'll recall the testimony of Gary Shrewsbury, the victim in that robbery case, who appeared here and testified to you about what happened, how Mr. Bradley had held a gun to his forehead, that actually tapped him in the forehead with the barrel of the gun, and threatened to kill him during the course of that robbery that took place, or at least that he was sentenced for back in March of 2009. Clearly, and I believe the court is going to instruct you, robbery is a crime of violence. Coupled with the testimony from Mr. Shrewsbury about the use of the firearm during the course of that robbery, threat to kill him, tapping him on the forehead with the firearm, that clearly establishes a crime of violence. And I submit to you that the third aggravating circumstance has been proven beyond any reasonable doubt. A fourth aggravating circumstance is that the capital felony was committed while the defendant was engaged in the commission of or flight after committing a robbery. In this particular one, we're talking about the robbery that you all have found beyond a reasonable doubt that occurred at the Econo Lodge shortly before Deputy Pill was killed. Clearly, Mr. Bradley was in the process of fleeing from the Econo Lodge at the time of the murder of Deputy Pill. You recall the testimony that the spot where Deputy Pill was killed was only 3.5 miles away from the Econo Lodge. It was just a short jog down 192 and then a left-hand turn down John Rhodes Boulevard to get to that location, and it took 10 to 15 minutes after the robbery where the shooting took place. You'll recall Ms. Kirchner's testimony that they had stopped no place in between. It was a direct shot for them. They left the hotel after the robbery, trying to get away so that they knew that the police were coming. They took off in the vehicle and then were stopped, first spotted by and then stopped by Deputy Pill, at which time the defendant shot her dead. Clearly, they were in the flight after committing a robbery, so that aggravating circumstance has been proven beyond a reasonable doubt. The fifth aggravating circumstance is that the capital felony was committed for the purpose of avoiding or preventing a lawful arrest or effecting an escape from custody. You'll recall the testimony from Ms. Kirchner, Mr. Villegas, even Amanda Osborne. The defendant knew he had outstanding warrants for his arrest, and he was not going back to jail. Not going back to jail. He knew he had just been involved in the taking of property at minimum from the hotel, possibly the robbery, because he knew that he had used the threat of force of running the maintenance man over if he didn't move out from in front of the vehicle. He knew that he was in trouble for that. He knew he was in trouble for violating the terms of his probation, and he did not want to go back to prison. Clearly, he shot and killed Deputy Bill for that reason. Now, the judge is going to tell you, I mentioned earlier, that there is a doubling effect between that particular one where the capital felony was committed for the purpose of avoiding or preventing a lawful arrest or effecting an escape from custody, along with the aggravating circumstance of that the victim of the capital felony was a law enforcement officer engaged in the performance of her official duties. Obviously, she was the person who was trying to apprehend Mr. Bradley, who was about to discover that he had the outstanding warrants and would have taken him back to prison. And she was shot because she was in that position. The court will advise you that although those two, if you believe that each of those has been proven beyond a reasonable doubt, they have a doubling effect, so you should consider the two of those as one aggravating circumstance together. Finally, the sixth aggravating circumstance that the state alleges in this case is that the capital felony was a homicide and was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. The judge is going to give you some instructions on what that particular aggravating circumstance means and the terms of it mean. And I believe she's going to tell you that cold means the murder was the product of calm and cool reflection. Calculated means having a careful plan or a prearranged design to commit murder. A killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. However, in order for this aggravating circumstance to apply, a heightened level of premeditation, demonstrated by a substantial period of reflection, is required. A pretense of moral or legal justification is any claim of justification or excuse that, though insufficient to reduce the degree of murder, nonetheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. Was this a cold, calculated, premeditated killing? Let's look at the evidence. We know that Mr. Bradley was aware that he had warrants outstanding for his arrest. The police were looking for him since February of 2011. We know that he had made the decision that he was not going back to prison. Miss Ellison, the girlfriend that he had from, I think, May of 2010 up through sometime in 2011, told you that she was aware that when she first met him, he had just been released from prison and was on probation. And at that point, he still was reporting to probation when they first met. But there came a time when he stopped reporting to probation, and warrants were issued for his arrest, and she urged him to turn himself in, but he refused. Mr. Bradley made the conscious decision, I am not going back to prison. Not going. No matter what I have to do, I am not going back to prison. How long did he have to think about that? And what did he do to prepare himself so that he wouldn't be taken back to prison? He armed himself with a gun. You heard the testimony of Robert Marks. November of 2011, he stole the gun from his brother-in-law and sold it to Mr. Bradley. November of 2011, 4 months before the murder of Deputy Bill, this defendant has armed himself and is making the conscious decision that he is willing to kill rather than going back to prison. But it's not just those witnesses. Amanda Osborne, in December of 2011, she's with him, sees how spooked he gets when they see a bunch of police cars while they're driving around one day, and he says, I don't want to go back to jail. I'm not going back to prison.
Yes, you may.
Oops. One thing I should point out is that your recollection of what the testimony is in the case is what counts in the case. Not what I tell you I believe that I heard during the course of the trial, what my notes might reflect. It's what your joint recollection is. We, as attorneys, hear a lot of different things, see a lot of different things that you all might not necessarily hear or see. Sometimes we get those mixed up when we talk to you. In this particular case, you all will make a factual decision about what it was that Ms. Osborne said occurred back in December of 2011, but certainly she talked about how Mr. Bradley was spooked when he saw the police cars, when he saw police vehicles, and that he said he would run at a minimum if he were apprehended or if he was stopped by the police. But what else do we have to show the cold and calculated and premeditated, heightened premeditated situation in this particular case? We have the events of March 6th of 2012. We have the fact that Mr. Bradley started thinking about what was going to happen to him if he got pulled over, at least as early as when he drove away from the hotel. As I discussed with you in closing arguments in the guilt phase, at that point he knew that the hotel folks had called 911. He knew the police were on the way. He knew that they had his tag number, the description of his vehicle, and he had to be thinking from that point forward, what am I going to do to keep me from going back to prison? And he had to really kick it into high gear when he saw Deputy Phil's patrol vehicle coming at him as he was going northbound on John Rhodes Boulevard, there by the Lamplighter Village place. As he saw a marked patrol car coming at him, look him in the face as they passed by each other going in opposite directions, and then immediately make a U-turn. That's not something that we all are not unfamiliar with. Seeing a police car do a U-turn right behind you, it's always usually bad news for me, but in this particular case, you can't help but believe that Mr. Bradley really went into overdrive in thinking about what he's going to do at that point. And what do we have from that point forward? We have a period of time where Deputy Phil drives to catch up to Mr. Bradley's vehicle and finally does there by O'Galley. We have the period of time that she turns the light on, the overhead light, chirps her siren to get his attention to pull him over. We have the full 3 minutes and 52 seconds from the time that camera went on until the bullet started coming out of the barrel of his gun, of Mr. Bradley thinking about what he's going to do to go back and prevent going back to prison. And we know what his decision was because we saw it on camera. We saw it 8 times. We heard it 8 times. He decided to shoot Deputy Barbara Bill to death for no other reason than that he did not want to go back to prison. I submit to you that the cold, calculated, and premeditated nature of this crime screams to you that this has been proven beyond a reasonable doubt. If you find each of those aggravating circumstances has been proven beyond a reasonable doubt, then you have 5 separate aggravating circumstances that you can consider as establishing that this is a proper death penalty case. And if you do that weighing process at this stage, just looking at the aggravators alone, I submit to you that your decision should be that those 5 aggravating circumstances would justify the imposition of a death penalty. Therefore, you go to the next step. You now look at the mitigators, determine by the greater weight of the evidence whether the mitigators that are alleged have been proven. Let's look at what some of the mitigators are that have been claimed in this case. First, they claim that the capital felony was committed while the defendant was under the influence of extreme mental or emotional disturbance. Well, we have a conflict in the evidence on that point between Dr. Olander, who was called by the defense, and Dr. Patricia Zapp, who was called by the state. Dr. Olander has given her opinion that, yes, the defendant was under the influence of extreme mental or emotional disturbance. Dr. Zapp says, I examined him, I looked at the same stuff Dr. Olander did, I don't find that. He scored well on all of the tests, not the top of the tree, but he had a C+ or B- average in school. He graduated from high school. He was functioning well in society. I mean, he was out there. He wasn't receiving any professional help, had made no made no claims that he needed any type of professional help or mental health help. He was functioning within society's norms, at least up to the time of March 6th of 2012, when he was taken into custody. Another mitigator is alleged that the capacity of the defendant to appreciate the criminality of his conduct or to conform his conduct to the requirements of the law was substantially impaired. Once again, we have the dispute in the testimony between Dr. Zapp and Dr. Olander on that point. One saying yes, one saying no. You all will have to make up your own minds on this one. You have expert testimony on both sides of the aisle on that situation. You've heard testimony about the lack of any records indicating that Mr. Bradley was having or suffering any type of mental illnesses prior to the shooting of Deputy Phil, and you will have to make that decision. One other mitigator alleged is that the age of the defendant was 22 at the time of the crime. That's not really in dispute, the age of Mr. Bradley. But I submit to you, age 22 is not exactly a mitigating factor in the situation. It's not an underdeveloped teenager who is going through a crisis of trying to fit in. This is a full-grown adult man, graduate from high school, who had made his own life out on the streets. He chose parts of the life that he lived, not all of it. You all heard the testimony of the brothers, others that knew him. There are certainly things that have affected Mr. Bradley that were beyond his control. But certainly many of the things that have affected him were by his choosing. You know, hear a mitigator or alleged mitigator that the defendant was severely physically abused as a child, that he was verbally and emotionally abused as a child, that his mother chose his stepfather over her own children and failed to protect him from their stepfather's abusive treatment, that the defendant witnessed the physical, verbal, and emotional abuse of his siblings by his stepfather. The defendant witnessed the physical, verbal, and emotional abuse of his mother by his stepfather. As a child, the defendant had no loving father figure or male role model. That the defendant had a close, loving relationship with his brother Anthony. That the defendant is known by his family and friends to be generous and contributed financially to the support of his mother and friends. I submit to you those things aren't really in factual dispute, and they could be for granted that they are established for the record in this case. There's no contrary testimony by anybody that disputes that Mr. Bradley was abused by his stepfather, as well as the two brothers were the two that testified about what happened. But does that justify the killing of a law enforcement officer? Certainly, the two brothers who came in and testified about what had occurred as child, during their childhood as well as Mr. Bradley's childhood, walked through the front door of the courthouse, walked through the front doors of the courtroom to come in and testify. They weren't brought here like Ms. Kirchner or Mr. Marks, in chains, with shackles on their feet, prison uniforms. How is it that the two brothers, apparently functioning quite well, and they haven't been charged with killing a police officer, if they suffered the same abuse as Mr. Bradley? One of the mitigators alleged is that the defendant was addicted to and abused drugs from an early age. I know that there was a lot of talk when you all were selected as jurors as to whether or not you would consider drug abuse or drug addiction as a mitigator or an aggravator in this case. And I believe that all parties stress to you that it is not an aggravating circumstance. It can't be considered as an aggravating circumstance in this case. But I suggest to you it's not exactly a mitigator either. The fact that Mr. Bradley abused drugs, whether he abused them from the age of 12 on up or just started more severely abusing drugs in the few weeks immediately prior to March 6th of 2012, either way, those were voluntary decisions by Mr. Bradley to engage in that behavior. This is not a situation where he was severely injured somewhere and was prescribed medications by a physician to treat the illness and somehow became addicted to them and began to abuse them after that fact. This is a person who made a conscious decision to take drugs, to take illegal drugs. And he made that decision every single day that he was using those drugs. He made that decision on March 6th of 2012. You're going to hear that one of the alleged mitigators is that the defendant suffers from brain damage and brain functional deficits. Well, you certainly heard the testimony from Dr. Wu about the PET scans and the MRI, DTI scans that were done that show brain damage in Mr. Bradley's brain. And Dr. Wu went to great lengths to establish that, well, that had to come from one of those three instances of head trauma that Mr. Bradley suffered. Fall off of the monkey bars where he landed on the head and became unconscious at school. The motor vehicle accident in 2008 where he claimed he hit the windshield, lost consciousness, or the time that he was in prison and he got hit in the head when another inmate threw a lock at him, hit him in the head. So if those were the three choices, and any one or a combination of those three are what caused the images that were shown on the PET scan and MRI scan to show abnormalities, well, then they obviously had to have occurred prior to March 6th of 2012. So on March 6th, he had those brain problems, and they could have affected the way he was thinking. Not did affect, but could have affected. And the reason he says that is because he acknowledged that there are people who show brain abnormalities on these scans, but have absolutely no symptoms related to it. Their functioning is just fine. They are not affected by what shows to be brain damage on the scans that are done, the PET and the MRIs. But even more telling was on our cross-examination of Dr. Wu, what about that other motor vehicle accident that the defendant was in? What about the one that took place after the shooting of Deputy Phil? Couldn't that have caused brain damage that you're seeing on these scans? Why isn't that responsible for it? And if that is the motor vehicle accident that actually caused the brain damage that you're seeing, even if there is an impact, it didn't happen until after the shooting. And why should we believe that the motor vehicle accident of March 6th of 2012, the one that you all saw in the videos, the one that you saw from the helicopter video as you watched the vehicle going into the ditch, the one you saw from Officer Cooper's in-car cameras, he followed the SUV as it was trying to escape down John Roach Boulevard and onto Parkway Drive. Why should we not believe that it's that accident, and why should we believe that it's the one, the three instances that happened earlier? First, the very first time that these doctors discovered that there was the brain trauma, or the brain injury or abnormalities, was in late 2013, a year and three-quarters or so, year and a half, after the shooting of Deputy Phil when they did the scans. And what had occurred prior to that time to document that there was any head injury whatsoever to Mr. Bradley? Mr. Bradley first related these three possible head injuries to Dr. Olander in her interviews of him, which began in March of 2013. And what records were we shown to establish that these instances actually even happened? No school records whatsoever indicating anything about a fall from the monkey bars, falling on your head and becoming unconscious. And I submit to you, that's just unreasonable. Like I argued to in closing arguments in the guilt phase in this case, it is unreasonable not to have any record whatsoever on school property and school grounds at school, falling from the monkey bars and becoming unconscious. You don't have that happen at school and just get up and walk away from it as if nothing ever happened. That's going to be documented. What about while he's in the Department of Corrections and he's hit in the head with a lock? They want you to believe that he's hit so seriously that it's caused organic brain damage to him, and yet no documentation. You've seen the records, or you haven't seen the records themselves. You've heard the experts testify about the jail records that they have reviewed, and no such incident is ever mentioned in those records. What is mentioned is the motor vehicle accident of 2008, the one where Mr. Bradley, when he tells his doctor about it, claims he was going 60 miles an hour as a passenger in a car, that he was T-boned, he was knocked unconscious, he had to go to the hospital, he's got all sorts of severe problems from that. But what did the actual hospital records show? They show that he appeared at the hospital 2 days after the accident, having declined medical treatment during the accident itself. and he appeared 2 days later complaining about, I believe, a neck injury and a knee injury, was diagnosed with whiplash and given some medications and sent home. That's what the records show. Certainly don't show any major head trauma, anything that would justify organic brain damage to be diagnosed 2 years later. Actually, now we're talking about a 2008 motor vehicle accident with 2013 tests, so we're talking 5 years or so later. For the first time, it's showing up, and you relate it back to that. I submit to you that the more reasonable thing to believe is that, in fact, this brain deficit or brain damage and injury occurred during the motor vehicle accident of March 6, of 2012, after Deputy Bill was shot. There we know what happened because you saw it on video. We know that Mr. Bradley was not restrained by seat belts in that accident. We know he was lying on the floor looking out at the police afterwards. We know from the DOC records that shortly, not the DOC, the Polk County facility over in Seminole County, where he was taken and held in jail, that he complained 2 days after the accident of having a fractured hand. They x-rayed it, and in fact, he had a fractured hand from the accident. I submit to you, if there is brain damage, number one, it has had no real impact on Mr. Bradley, or if it did, all of that impact arose after the shooting of Deputy Bill, when he was running from the law in that March 6, 2012 car chase and subsequent crash. Another mitigator is that in October of 2011, Trevante Williams, the defendant's cousin, was shot to death, which had an emotional and psychological impact on the defendant. All right, the defendant's had relatives die in some sudden, unexpected ways. Certainly that impacts everybody, but does it justify the killing of a uniformed police officer? I suggest it does not. Another mitigator is the defendant had a 2-year relationship with Carrie Ellison, during which she became pregnant with his child. She testified about that, about the miscarriage that occurred a few days after the death of Mr. Williams, the cousin. And that thereafter, the defendant began a period of significantly greater drug abuse. Once again, a choice by Mr. Bradley to voluntarily take drugs, take illegal drugs. That may have been his method of escaping, or dealing, or coping, or whatever, but once again, this is a voluntary decision by Mr. Bradley. And here that an alleged mitigator that following the loss of his cousin, he became paranoid and believed that it was placed on his life and obtained a gun to protect himself. There is testimony that those were some of the motives of Mr. Bradley, but I submit to you that they also established the paranoia of not wanting to go back to jail and knowing that law enforcement officers are looking for you. That goes hand in hand, and I submit to you the obtaining a gun wasn't just because he was concerned about a hit, but rather he was concerned about not wanting going back to prison and needing to do something to take steps to prepare himself for the day he may be confronted by law enforcement who would try to force him to go back to prison. Another mitigator is that several of the defendant's friends and relatives were murdered or died, which appeared to emotionally affect the defendant. People die. It is a fact of life that one of us, or all of us, at one point in the course of time is going to be confronted with. We are all going to die. All of your relatives are going to die. It's going to happen. But it does not justify the killing of another human being. The defendant has been diagnosed with polysubstance dependence, which is in remission in a controlled environment. That is, he's in jail and he can't get the drug, so he's sort of in remission for that particular problem. And there's a passive and dependent personality traits. It may very well be that he's got these problems, but once again, dependence problems, the polysubstance abuse dependence is of his own making. The defendant has a full-scale IQ of 70, as assessed in 2013 by the WACE score that was administered by Dr. Olander and her staff. But he was a functioning human being. We're not talking about someone who had to have full care on a daily basis to take him places, to tell him what to do, and to hold his hand. This was a man who functioned on his own. He was out on the streets, living the life that he wanted to live, chose the life that he wanted to live, and was living it. The defendant was cooperative with law enforcement and confessed. I agree. He cooperated. You saw on the videotape. He was read his rights. He said he understood them. He was willing to talk and explain to the officers how he shot and killed Deputy Phil. Finally, the existence of any other factors in the defendant's character, background, or life, or the circumstances of the offense that would mitigate against the imposition of the death penalty. That basically is anything else about the defendant or the circumstances of this case that you think would mitigate against the death penalty. I submit that, like we discussed just now, a number of these mitigators do in fact exist. But the fact that they exist does not mean that you should give them great weight. It does not mean that they would outweigh the aggravating circumstances that have been proven in this case beyond any reasonable doubt. I submit that if you follow the process that Mr. Brown outlined, and the jury selection, and weigh the mitigators against the aggravators, all of those different potential mitigating circumstances, if you believe them, if they believe that they occurred, weigh them against the aggravating factors that exist in this case. And you all get to decide how to do that weighing process. The court isn't going to give you any real help in her instructions about how you make that weighing decision. You all get to come up with that, each and every one of you, on your own, and make a decision about weighing those circumstances. I submit to you, though, if you use your common sense, and that's one of the things the judge is going to tell you, that just because you're on this jury and there are a number of technical things that we go through in courts of law, you don't have to leave your common sense behind. And I submit to you that if you consider the evidence that has been presented in this case, particularly as it relates to the aggravating factors and these mitigating factors, you will decide that the aggravating factors in this case far outweigh the mitigating factors that the defense is going to argue. So that brings us back to the question. Why is the death penalty the appropriate sentence in this case? This is not the defendant's first rodeo. This defendant has had numerous chances. He's on probation, 4 separate felony counts, one of which was a prior robbery, a violent crime. Not only is it violent in nature, just by the nature of the crime of robbery, but you heard how he had a gun, was willing to put it to the forehead of the victim that was robbed in that situation, Mr. Shrewsbury, and even threatened to kill Mr. Shrewsbury. He was given a chance, even with that case. Originally had been on probation, if you recall Officer Cologne's testimony on one of the cases, and then violated his probation with robbery in another case, was sent to prison for 2 years to be followed by another chance at probation. Another chance where he is told, yes, you have done things wrong in your past, but this is now your opportunity to change your life, to turn yourself around, to start following the law, to start living a law-abiding life. And what does he do? He quits going to the probation. Runs away from the probation. I got my own life to live. And when he's told by his girlfriend, Miss Ellison, turn yourself in, get this straightened out. Now, I'm not ready. Maybe some other time, but I'm not ready. I'm not going back to jail. And what happens next? He commits another robbery. While he's on probation on the first one and 3 other felony counts, he goes out and he commits another robbery. The one you found him guilty of at the Econo Lodge. And what does he do after that? He kills Deputy Hill trying to escape from the new robbery, trying to escape from going back to jail on the probation cases. He guns down a uniformed deputy, the Brevard County Sheriff's Office, who never threatened, whose only crime was to tell him 23 times to get out of the car. 23 times. Listen to the video. Deputy Hill, get out of the car, I need to talk to you. She's investigating what she thinks is just a theft of property from a hotel. She doesn't know that it's actually a robbery because of what was done with the maintenance man. She only knows it's a theft of property. She's talking to what appears to be a fairly young man, asking him to get out of the car so she can talk to him and clear up the situation, find out what happened. And what does she get for trying to talk to Mr. Bradley? She gets shot in the head. She gets shot in the arm. She got shot in the back. The victim, Barbara Bill, is a law enforcement officer. During jury selection, you heard the judge ask questions of each of the jurors. Do you know any law enforcement officers? Do you have any law enforcement officers in your family? Do you have any good friends? Anybody that's in law enforcement or has been in law enforcement? You can't consider a law enforcement officer's testimony or give it greater weight than you would any other witness. They're just like any other person. For the purposes of determining their credibility, understand all of that is exactly accurate. For determining whether this is a death penalty case, the Florida legislature says yes, that is important. Yes, it's important. A law enforcement officer is the victim in performance of their official duties. That is the very first aggravating circumstance that I discussed with you. The Florida legislature has decided that as a policy decision, we protect those who try to protect us. Deputy Pill was in her marked vehicle, wearing her uniform, carrying out her duties that day, and she was shot to death. That alone cries out for the death penalty. That alone, even putting aside the other 5 aggravating circumstances, that alone justifies the death penalty. When you go back to the jury room, I urge you to talk to your fellow jurors, express your opinions, discuss the weighing factors of mitigating versus aggravating. I submit to you that if you do, you will come to the same conclusion that justice calls for, that the Hill family calls for, that the Brevard County Sheriff's Office family calls for, the law enforcement family calls for.
Here, Jermaine. Ladies and gentlemen of the jury, you are to disregard any comments made by the state as it relates to what the law enforcement community wants and the wishes of the family with regard to a sentence. This is not to be considered by you in your deliberations. Okay, Mr. McMaster, you may proceed.
Look to the evidence in this case, ladies and gentlemen. Look to the evidence. And if you do, I submit that you will conclude that the evidence in this case demands that you recommend a sentence.
Yes, you may.